Hello viewers and welcome to the set The Future of Europe. Today we are exploring the dynamic of intersection of technology and data protection. Joining us, a special guest, currently doing an LLM in international and European law at the Catholic University at Lille. Welcome, Cyrine.
Good morning, thank you for having me.
We're excited to dive into this crucial topic with your insights. Our conversation will touch on the challenges presented by evolving technology within the European Union. Our conversation begins with a fundamental question. In light of the evolving technology landscape, we think it's insight into how these changes have influenced the European Union's approach to data protection. Could you elaborate on the impact of this?
Yes, of course. The evolution of technology has influenced the European Union approach to data protection. And as technology advances, so do the challenges associated with data protection and protecting individuals' privacy rights. The EU recognizes this dynamic landscape and tries to improve its regulation. And one key aspect of this improvement is the General Data Protection Regulation, which is really important to and remain relevant and efficient to protect individuals' privacy rights. And this can also respond to the evolution of technology, for example, artificial intelligence, as it today is a real concern for individuals. And also it serves as a reminder that data protection must evolve alongside technology and to maintain the highest standards of privacy and security for individuals within the EU.
I understand that the EU seeks to safeguard the privacy rights of its citizens. But could you provide us a recent example on how the Court of Justice of the European Union addresses technological advancements?
Of course. And it's a conflict that revolves around the decision by the Federal Cartel Office in Germany to prohibit data processing of users on and off Facebook, and the Meta platform Ireland relies on advertising for revenue, and this advertising is basically based on the data processing and collecting data from users' account on Facebook, and it's on and off the platform. And Meta relies also on the user's agreement which link data collection to the Facebook account of users. And this investigation by the Federal Cartel Office has led to a legal proceeding initiated by Meta against this decision. The questions raised for this decision include the competence of national competition authorities to review the GDPR compliance and the legality of this personalized, sensitive personal data, and also the legality of the validity of the consent, and especially when given to a company like Facebook with a dominance market in the market for social networks.
But what did the court decide on these issues?
So the CJEU issued its decision in July 2023, so it's really recent, and it emphasizes the importance of sincere cooperation between the competition authority and data protection authorities. And it defined a really important thing it's the processing of special categories of personal data and clarifies the circumstances under which user actions make data public. The court also outlined the conditions for lawful data processing, emphasizing the necessity of consent, but also the court gave a really strict interpretation of necessity to protect the privacy right of individuals. The court specified on this context, in the absence of, on their part, the interests of individuals prevail over the interests of the operator, even if this operator finances its activity from this advertising. Additionally, it highlights also the justification for data processing based on legal obligation and the role of user consent in the context of a dominant market position. The court wants to ensure that users have the freedom to refuse non-essential data processing, offering them the ability to provide separate consent for off-platform data processing, for example, for WhatsApp or other companies.
Okay, so what about the jurisprudence? Is it the first time that the Court of Justice of the European Union renders a decision that protects the privacy rights of users of social networks?
Of course, no. So the CJEU aligned its decision with the Schrems case law, which was against Facebook, and it's a landmark legal battle that revolves around data protection and individual privacy rights. Within the European Union, Max Schrems, an Austrian privacy rights activist, filed complaints against Facebook and alleged that the social media giant transferred data to the United States and based this on the Privacy Shield agreement between the US and the European Union. And the CJEU in this decision invalidated this Privacy Shield agreement and also highlighted the EU's commitment to upholding high data protection standards globally and ensuring that individuals' privacy rights are respected regardless of where data travels.
Based on what you just mentioned, what insight can you share about the Court of Justice of the European Union approach onto data protection and privacy rights?
So, like I mentioned for the Meta case or the Schrems case, the CJEU dedication revolves around safeguarding core European Union principles, and particularly those related to data protection and individuals' rights. The CJEU ensures that personal data of users on social network is treated with the highest regard for privacy, security, and complaint with EU laws and regulations, notably here the General Data Protection Regulation.
What is the consequence of this decision on privacy rights of social networks users in the future of Europe?
So to make it clear for everyone, this ruling first ensures that companies like Meta cannot justify data processing that may go beyond what is generally essential for the fulfillment of a contract. It reinforces the importance of precision and necessity in data processing under this legal basis to protect individuals' privacy rights. It also recognizes that data protection and competition law are not isolated concerns, but often intersect, especially in the context of tech giants with their vast data ecosystems. It reinforces the idea that competition law can be leveraged as a mechanism to uphold fundamental rights, and here the right to privacy. In essence, it highlights that competition authorities have also an important role to play in ensuring that companies like Meta do not abuse their dominant position to infringe privacy individuals' rights. Sorry to respond to your question now.
Yes, sorry.
This approach has a broader trend where legal systems are evolving to adapt to the digital landscape, acknowledging privacy and competition and data protection. It underscores the need for a comprehensive approach to safeguarding fundamental rights in the digital era, where data has become a valuable currency and privacy a concern for individuals. So this ruling safeguards against this manipulation of the companies that have market dominance in the EU, ensuring that these companies do not disturb the market landscape for their advantage, and it underscores the interconnectedness of the legal frameworks in addressing contemporary challenges posed by the digital age.
Sorry. So as we conclude today's insightful discussion, I want to express my gratitude to our esteemed guests for sharing valuable perspective on data protection in the European Union, especially in the context of evolving technologies. To our viewers, thank you for joining us in this discussion. We hope this conversation has provided clarity and sparked further curiosity about the evolving landscape of data protection. Until next time, take care and stay informed.
Thank you for your questions. It's been a pleasure discussing these important issues with you.